Good morning. Are you Travis Smith? And Mr. Smith was previously in court, entered a plea of guilty to theft of property with previous convictions. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
I've read it, John.
I have, Judge.
Are there any additions or corrections?
No, well, one thing is it's an addition, and I just found out about it Friday. In the report, it says his mother abandoned him at 3, which is true. But she's now straightened herself out and she's helping run a rehab center in Lafayette, and it's going to become part of his life. He's got 2 uncles here. So he has, they're in the courtroom. He has strong family support,
Okay,
a lot stronger than what that says.
good. Thank you.
Uh,
I am also going to take judicial notice of the court's file. Mr. Smith was previously found not competent and was sent to the John Dunn Behavioral Science Center and restored competency. Any issues right now before sentencing with competency?
No, I think have you been taking your medicine in jail?
Okay.
I don't think so, yeah.
Okay,
But
perfect.
I'd have to be a psychiatrist to truthfully answer it,
Okay.
correctly answer it. You know.
All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property with previous convictions. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. But that will be probated for 5 years, so you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That is going to include being on the mental health caseload so that you can get whatever help you need. Follow all of those recommendations, meetings, medication, whatever. That's all part of your probation now. You do all of that. This is a great opportunity for you to get your life back on track. And you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand?
Yeah.
I'm handing you 2 things. One is the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams.
Judge's misdemeanor will be dismissed.
Yeah,
Okay,
that's what I was
thank you.
gonna say.
All right, so they'll get that misdemeanor dismissed as well as part of that this morning. Okay, good luck to you.
Thank you, Honor. He be released today.
He should be,
Yeah.
yeah, as long as there's no other hold that misdemeanor, once if there's nothing else in the other county. But if it's just this, yeah, you should be released today and you'll get some instructions today before you leave the courtroom from probation. To tell you exactly what to do when you're released, okay? Okay,
Thank you, Honor.
yes, sir. Good morning, sir. Are you Jermaine Alexander? And this is 26 DCCR 0178. Mr. Alexander is charged with injury to a child, elderly or disabled individual. And what is the announcement?
Your Honor, we're going to ask for some more time. I'm still waiting for some discovery. I have not gotten any of the videos yet. Did talk to Mr. Smith about that. We're thinking they might be online, but they weren't given to me yet. So I'm going to double check.
Okay, so if y'all will both check on that. And so, Mr. Alexander, I'm going to reset your case so that Ms. DeLage can get all of the videos and everything that the state has. And she'll be able to be out there hopefully before that next court date to go over all of that with you, show you everything. And then we can get an announcement at the next court date. Okay, you go back with the bailiff.
Just
Good morning, sir. You Brian McWade? Yes, ma'am. And this is cause number 26 DCCR 0402. Mr. McWade is charged with aggravated assault with a deadly weapon. Mr. Macon has filed a motion asking that I set a reasonable bond. What is the bond currently?
$500,000.
Were we here already on a bond?
That was the first motion I filed to try and lower the bond, and we denied it.
This is April.
Right. I
April
usually
22nd.
I usually don't do this twice.
Oh, okay.
Unless something, significant has changed, if there's some new evidence. Other than that, it's just a matter of if the case is gonna go to trial, then there can be a rejection and we can get it set as quickly as possible. But unless there's new evidence with regard to a bond, I'm not going to hear the same evidence again. The fact that he's still in custody isn't necessarily new evidence.
He has a job waiting for him with Utah, right? As an electrician.
Okay. Ms. Malfino,
Judge,
does the state have?
I apologize. This was formerly a 5A case, and I don't know if maybe it got piggybacked along rather quickly and it was not on our docket. If you could give me a few minutes, I'll either go get it. I would appreciate the opportunity to at least review it. Its court has already heard this. I'm sure my position will be the same as Mr. Coleman's originally was.
Yeah, and it shows on my docket that it's Mr. Nichols. Is that not correct?
It may be, Judge. I think it was an add-on. I didn't have it on my docket, didn't have it pulled for this morning. But we'll get it good.
Okay, well, it's on the regular docket, so it wasn't added on too late, but maybe it was a week or so. Let me hold it for a minute. Just go back with the bailiff.
Some of that is the numbers change.
Good morning, sir. Are you Pedro Martinez?
Yes.
And this is cause number 26 DCCR 1085. Mr. Martinez is charged with assault, family violence by impeding breath or circulation. Mr. Rojas, what is the announcement?
Judge, if I may, have a name called and document a few things for the court's record.
Sure.
The name of the complainant is Margaret Samano.
Margaret Samano.
Margaret Samano. Oh, God.
Judge, may the record reflect that the complainant, Ms. Samano, has not appeared in court today. We're not surprised by that. I did make every attempt to reach out to her, known information I had. I also asked my family violence investigator, Ms. Guidry, to reach out to her. It's apparent to us from one, she non-prosecuted, so to speak, in the offense material. And two, I don't believe she has a permanent residence, and they have attempted to track her at some known locations for people who don't have a stable place to reside, unable to do so. We did find one email to her at a Gmail account. We made every attempt to send notification there to please contact us both in English and in Spanish. She has yet to respond, Judge. Obviously, the nature of the offense is concerning with it being a family violence, but on the other hand, the fact that the defendant has been in custody, I feel with that information, it was my duty to, at this time, move to dismiss, and if further information comes to light, I will bring it to the court's attention.
Okay, then I'll sign that. Obviously, Mr. Martinez, I'm taking a look now at that probable cause affidavit. So something went on that night that shouldn't have gone on. And the fact that she isn't cooperating, makes me very concerned, but it is what it is. If you end up back in here, or if she changes her mind, they could re-indict your case, but whatever was going on you need to stay far, far away from that.
Yes.
All right, you can go back with the bailiff.
Thank you, Judge. I'll send it out.
I'll sign it as soon as it comes through. Jamie, are you Luciano Sevilla Jr.?
Yes, ma'am.
And Mr. Sevilla, the best you can, would you raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Mr. Parker, will he waive the formal reading of the motion?
Here we go.
Mr. Sevilla, in clause number 22-39617, I have a motion to revoke your community supervision. Shows that you were placed on probation November 30th of 2022 for the 3rd-degree felony offense of stalking. And that was a 7-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of criminal mischief, May 23rd of 2026 in Orange County, Texas. And is that true or not true?
That's true.
Count 2 alleges that you committed the offense of stalking, May 22nd of 2026 through May 28th of 2026 in Orange County, Texas. And is that true or not true?
It's true.
Count 3 alleges that you failed to, it's really the same.
It is, Judge. This was a motion that was filed rather quickly at the court's request, so I put everything.
Yeah, no, that's fine. I appreciate that. I'm gonna skip 3. Count 4 alleges that you violated a term and condition of your probation by prohibiting the possession of a firearm, in that you were in possession or observed in a video displaying and possessing a shotgun and a red shotgun shell on November in November of 2025. Is that true or not true? Count 5 alleges that you violated the term and condition of your probation that required you to have no contact with the victim, Cynthia Gonzalez, and that on May 23rd of 2026, you sent text messages to Cynthia Gonzalez in violation of that order. Is that true or not true?
That's true, Mom.
Count 6 alleges that you are behind in your court assessed fees as of June 2nd of 2026 in the amount of $349. And is that true or not true?
That was complicated. I would always pay. I never had problems paying.
Well, it was just as of that date. So
Oh.
that's fine. I'll put not true for 6. All right. Did you enter your pleas of true to counts 1, 2, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
That's true.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 5 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation. But I'm not going to do that today. I'm going to reset your case for a sentencing hearing, ask the probation department to do an updated report. Obviously, if there's any evidence with regard to the firearm allegation in count 4, we can hear that. It shouldn't take too long if you want to have somebody here on that.
Well, Judge, and just so you're aware, I did contact Orange County DA's office last week. They do not yet have that case. In anticipation of these pleas of true or not true, I reached out to them, also reached out to Detective Taylor at the Bridge City Police Department. I would like to bring him at the sentencing regardless of these pleas for the court. I think it'd be important based on the fact that he's on probation for the stalking. It's the same victim, Miss Gonzalez, in both cases. I've handled it since the beginning of it. So if you would allow us a little bit of extra time, I'd like to bring that detective
Sure.
as well.
And we could do that on a regular morning
Yes,
docket,
that'd be
but
fine.
yeah,
Just
that would
You
be,
note, I'll have a witness or two.
okay. Do you anticipate witnesses?
Just my client.
Okay, so we'll just make a notation that there will be witnesses and maybe put this one at 11 for a sentencing, and we'll get an updated pre-sentence report. Anything that you think is important for me to know, get that information to Mr. Parker.
I'll give him later.
I understand.
Yeah, just you'll talk before sentencing and he'll present all that to me on your behalf when we come back. All right, go back with the bailiff.
Come see.